Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
No, getting commentary on the case.
Literally not true.
Is that correct?
Dahil mihi Anglican police service Latinos. I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning, good morning. Welcome to the Court of Public Opinion. Happy Friday to you. I am the Recovery Addict. It is good to be here today. Hello. Hello, are you there? Hello. Welcome, you guys. Is that Ricky already? Ricky's at it already.
I'm trying to have food.
Ricky, I happen to know what your favorite command is. So, hello. It is Friday. A little disappointed yesterday. Hello. A little disappointed yesterday. I was looking at the weather. And it told me that here in my town it was going to rain on Halloween. Which is bad because that means I'll have 50 pounds of candy that I'll feel obligated to eat. And went to bed, woke up this morning, and the weatherman changed their mind. I said, never mind, Friday, Saturday are great weather. So I'm happy again. Yay. I was trying to figure out, maybe I need to get one of those tents, that like those evidence tents, those pop-up white tents that they have at a crime scene, and hand out candy from in there. But, have to give out handfuls of candy to everybody. All right, we've got to be quick. I'm sorry, I had a long morning going on, and so we have to be very quick and get set for birthdays. First of all, let's do that right away because we have very little time to celebrate before court starts. I think if they start on time. There's a song, birthday song. So hopefully we have some birthdays today. If not, it will be very sad indeed. Also need to celebrate Britta Aller, who was first in chat. Britta, bing, congratulations. Welcome, Britta. Appreciate it. I'm not sure. Let me see who sent. Oh, it was Britt Bottoms. Sorry. I was thinking it wasn't Britta. Britt Bottoms sent me something, came in the mail. I'm not sure if I'm going to be able to try it. It does not look good, but I'll give it a try. Anyway, welcome. Let's see. Where else? Oh, yeah, just birthday songs. Josh can add you next. It's Nexus's birthday. Wonderful. Where's Nexus? There you are.
Happy
can
birthday.
I have a belated
You look
birthday?
good.
Yes, we can do that. We'll add you to the belated birthday. I'm not sure if the command was working for Josh this morning, so we might not have birthdays yet. Oh, there they are. There they are. And he even added Nexus. Look at that. Alphabetical order. Thank you very much. We're going to sing happy birthday to Birdie, Danny D, Kay, Kimby, Laura M, Nexus, Nonisi, I think it's Nonisi, Pat H, Ron, and Sue, which might be a two-verser. Either way, everyone's singing. Stand up, deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. Whoa, that was not the warm-up song. That was Big Dill. It's a good song, but that's not what we're going to sing happy birthday to. Let's try that again. Warm up with me if you will. La 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 la. That was quite a wake-up, wasn't it? Here we go. Happy birthday to you. Happy birthday to you. Happy birthday to your Birdie, Danny D, Kay, Kimby, Laura M, and Nexus. Happy birthday to you. Sorry, I stumbled on Birdie. Birthday and Birdie too close together. So we're going to start with Nonis, Pat H, Ron, and Sue in verse 2. Happy birthday to you. Happy birthday to you. Happy birthday, Nisi, Pat H, Ron, and Sue. Happy birthday to you. And Pat H, happy birthday, 60 years old. That deserves a special mention all by itself. But Stephanie, happy birthday to Pat. Thanks for sharing your husband's birthday with us. Ron's my dad. His is tomorrow, says 80s. That's wonderful. Wonderful. Happy birthday to 80s. Music Man's dad. Why are you doubting me? I'm a busy man. Josh, I know you are. Put the fishing pole down and focus on the birthdays for just a minute. To everyone who's celebrating their birthday today, happy birthday. There are many wonderful days. Today is your special day. And I realize there are a million places you could be and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully, we can turn some of that joy we feel back to you, make your day a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. Woo! Wow, it's like I've said that before. Just rolls off the tongue. Happy birthday to everybody. Josh, thank you very much for the alphabetized list. When we get longer list, I'm doing it Z to A and not A to Z. Thanks. That'll be great. For your birthday, I got you muffins. Blueberry muffins, hot out of the oven. And I've got a mug of milk. Is this the drum solo? It was. It was. The drum solo snuck up on me like that. 2 verses will do that to you. Thank you, everyone who sang with Scott and my boo. You two rock and roll. Thank you. Thanks for including us Saturday, people. Of course. Everyone needs to be celebrated. Can I just say, I found a social media person, local here to Greenville, North Carolina, that I didn't even know existed, and she's killing it on social media. She's doing these little tiny short videos, and she's going around doing little spotlights on business, like a 60-second spotlight on a business. And she is hilarious. And she sort of went viral because she starts all her little bits. What up, fools? And it's in the nicest way. It's not like a rude thing. She's just, what up, fools? Here's what's going on. And she's funny. She's absolutely hilarious. And she gets to see like my whole town and everything that's cool about it. Her name is Emily McAllister, and this is what I like about it. All the spotlights she does on business, all the collaboration where she goes and, it's basically doing advertisement for that business is free. She doesn't charge for it. Zero, nothing. She's a realtor. She's selling houses. And she describes how great the area is, what amazing amenities and restaurants and businesses we have here. And people are like, I want to live there. Do you have any houses I can buy? And she says, yes. And then she gets the deal. And so she's selling a boatload of houses and listing a boatload of houses because everyone sees her social media. It's a brilliant marketing plan. And she's hilarious and funny. And she's a terrible golfer. And she shows everybody how bad she sucks at golf. She hit like a 58 on the back 9 or something. I forget what it was. But anyway, it was... It's pretty cool. I might have to see if I can help out with something they're doing because she does some cool stuff. All right, where are we? We're almost back in court. That's where we are. We've got the video for the most part here. Let's see if we can get the rest of it. Dustin Duren. That was not it. That's Jason Durant. That's not what I said. Clicky. Nope, not it. She's on Facebook, by the way. She's not. I think she might be on like TikTok, but she doesn't do much on YouTube, which is probably good because YouTube's hard to advertise geographically. That's not it. Clicky. That's some ASMR. Scrolling through everything. Bingo. Got it. All right, now we'll get everything synced up before court starts in case I decide to show more video. Where was I? Oh, I was bragging about this cool person in that area that she goes to Morehead City, which is a crazy name for a city, but it happens to be where like the big rock, bluefin. I don't know what it is. It's a huge. I'm not sure if it's bluefin. It's the marlin fishing competition, like when those $1 million rigs go out and catch those massive fish, and there's like $1 million prize. That's right here in North Carolina. It's like 2 hours from me. Not a bad name for a city. Can I kindly ask to file a motion to leave my car problems to someone else? Just pass them on down the line. I'm sorry, car problems are the worst. Car problems. The thing about car problems is they happen at the worst time too. I mean, it's first of all it's inconvenient, but they also happen when it's like it's inconvenient time and inconvenient financially and inconvenient, with their schedule. It's terrible, and then it takes forever to fix and too expensive. And you're like, why do I even have a car if I have to buy it again every time it breaks? Yeah. All right. Oh, I just saw Stephanie, the YouTube name, gifted 5 memberships. Stephanie, thank you very much for your generosity. Go Packers, right? Go Packers. Appreciate your support. And I think happy birthday to your husband. So let's see. LP Lewis 1, happy Friday, friends. Yes, 17 months. 17 months. Thank you very much. Okay, I've got to stop this one. Hold, please, for just a second. We're syncing everything up so it'll all match up perfectly. Waiting for a moment. It'll take a minute. Boom. Okay. Just waiting. I think we're about 30 seconds difference. Maybe a little bit longer. How's your weekend plans going? Is everybody? We got one more weekend before Halloween. I'm actually doing a trunk or treat this weekend, so we're going to give away a little bit of candy ahead of time. It's a daylight thing, so the black lights are not going to be very effective. I can't do the projector. I don't know. I don't know what. Pretty much, it's just going to be a whole bunch of crime scene tape and some chalk on the ground. I think is all we're going to do. And candy, of course, candy. Wait for it. Here we go. Holy cow, this is a long delay. We're about a minute apart. Indy Cindy, member for 28 months. That makes you an OG. Go Indianapolis Colts. That's going to be close enough for now. I missed it by a smidge. Perfect. Got it. All right. Now we're ready. When court starts, we'll bring you there. I have to work on the audio again because, that's how we roll. Oh, it's actually good. I left it from last time. All right. I'm staying home all this weekend. Very exciting. I'm a bridesmaid at a friend's wedding tomorrow. Can't wait for the open bar and dancing. Send pictures. Sounds like it's going to be a lot of fun. Congratulations to your friend, by the way. Can we get your thoughts so far? All right, played catch up the last couple of days. Next is Lexus. Sure. What we have here, Dustin Duren, charged with the murder of his, I say wife, but the mother of his 2 children, Caitlin. They had a separation, falling apart, financial struggle. 2 daughters, and the idea was the moving would help. He moved from Las Vegas to New Hampshire or Minnesota, and then to New Hampshire, and that part's confusing a little bit to me. But he had moved out with one of the daughters, and then she came in to visit, and her aunt drove her there, and they met like at the halfway point, like an hour and a half away, and then he drove back, and she was staying at his place like during the day, but she was supposed to leave that day. And she just didn't. and he didn't like that, and he kept pressing her for, why aren't you leaving? Why aren't you leaving? And eventually he's like, we're leaving. We're getting rid of you. You're leaving today. And she wouldn't leave. The fight started involving his oldest daughter, who was 4, and the mom was holding the daughter in a bear hug on her lap, and said, "I'm not leaving, not going," and allegedly said a bunch of other things as well, but about she was going to kidnap the kids and everything, even after she wasn't talking to him all day, and it's a weird situation. But it ended up in an argument where they were fighting over the daughter, and he grabbed his gun and shot and killed Caitlin, took the daughter, and left. Amber Alert was issued. They were found the next day pulling into a McDonald's, Chili's sort of combo, or was it Applebee's? I forget. And he talked. The police sat him down and signed his rights away, and he talked and talked and talked and basically told everything. I think just if we have nothing but the evidence of the crime scene and his version of the events, he's guilty. And unfortunately, that's pretty much all we've got. So it looks like it's going to be guilty here, probably across the board. Let's see. And it's second-degree murder is what they're charging him with. All right. Holy cow. Indy Cindy, congratulations. OG, 28 months. Another OG, Tash Becks. Tash, your name changed. Tash BX. I don't know how to say it. Member for 24 months. You just got that pink courthouse. It looks great on you. 2 whole years with my familia. Thanks, RA Mods in chat, for such a great community. Thank you, Tash. Appreciate that. Vivian Anderson. Member for 29 months. OG. 29 months is still going strong. Love it here. Thank you, Vivian. Also, Melissa Chris, 7890. Member for 13 months on the jury. Melissa Chris, thank you very much for your support. I've been here for at least 2 years. That makes you an OG. And it's a great place to be. Thank you, RA and Mods. It is a great place to be because you guys make it great. I would not be the same without you here. Appreciate that. And thank you for your huge support of the channel as a jury member. All right. Everyone is changing their names on YouTube, and it's slowly coming around. I see that. It's thrown me for a loop because I had you all memorized, and now your name's changed, and now you're changing it back to something else or something new, and it's put my head in a vice here trying to remember them all. But went to a banquet last night that honored my uncle for what he does in our community for the youth. That is cool. That is really cool. Tumwater Troy, another jury level supporter. Member for 25 months on the jury, OG. Tumwater Troy, thank you very much. Love that we can visit your neck of the woods frequently. I'm sorry it's under the conditions which we are, where people are a little bit different. You guys, you got it in spades up there in Thurston. We didn't do it, all right? We didn't do it. What's happening? I don't know. I know you didn't do the name thing. I've got a light that's not turned on. Hang on 1 second. There we go. Okay. When I come in my studio in the morning, I have to turn on 3 lights and 7 monitors or computers.
Jury, thank you again for your service
And I missed a light.
Punctuality, as I ask you every morning, because there is a media presence with respect to this jury. Please, I would ask you now to raise your hand if you have had any exposure.
Put your hands in the air.
Even if it was inadvertent relative to any of the media coverage with respect to this matter. Let the record reflect that none of the jurors have raised their hands. Thank you again for your adherence to my instructions. Thank you. And Attorney Kettle's ready to proceed?
Yes, Your Honor.
Detective Sergeant, you're still under oath, sir.
Yes, sir.
Ladies Music Command, you're an OG. Thank you. Okay, the volume's low. I've got it cranked. They're going to crank it on their end. I'll have to turn it back down again. So this is the game we play.
Detective Sergeant, I'm going to back us up a little bit and just go through in some bite-sized chunks, okay?
Okay.
So we were talking about the incident itself, what Dustin told you about the incident. He said it happened super fast.
Yes.
He said, I mean, there was, again, it was like training to where it was, he said, I mean, there was, again, it was like training.
Yes.
He said, to where it was just grabbed it, cocked, grabbed Elwin, and then right when I shot, it was just immediately I grabbed Elwin and like ran out of the house.
To the car.
Yes, I'm doing it in bite-sized chunks here. Yes.
Okay. Yes.
And just immediately ran out of the house and put her in the car.
Yes.
And they fixed the audio to be broken. This right now is the defense attorney questioning this investigator who interviewed the defendant. We're hoping the audio comes back here. Do we have it on the other side?
Didn't have injuries?
Yes.
She didn't.
Correct.
He loaded the car up.
Yes.
He got the kids in the car.
Yes.
He was thinking, at some point I'm going to turn myself in.
Yes.
But first he was going to spend some time with his kids.
Mm-hmm. Correct.
He said he drove to Concord.
Yes.
Once he got to Concord, he sat with Elwin and Valen again.
Yes.
And at that point, they were both good and they were happy.
Yes.
He called his mom and told her what had happened.
Yes.
And he told her to call the cops.
Probably should call the cops is my recollection, but something to that effect, yes.
He told his mom he was going to turn himself in.
I believe so, yes.
He told her he wanted some time with the kids beforehand.
Yes.
He told you that after he talked to his mom, he turned his phone off.
Correct. Went dark, I believe is what he said.
He said went dark, and he said, I turned my phone off.
Yes.
He said he drove to somewhere in New York State.
He believed it was New York State. Yes.
He and the kids got a few hours sleep.
Correct.
He woke up and initially thought, well, I'll just surrender at a random police department.
Yes.
But then he decided he should probably do it in New Hampshire.
Correct.
And by do it, he was referring to surrendering or turning himself in.
Yes.
So then he started heading back.
Yes.
He decided to go to Concord and then just surrender there.
That was his plan, yes.
But he wanted to just sit down with the girls and just have breakfast somewhere.
Yes.
Just a couple more questions on what Dustin said in relation to his training. Dustin said everything was so fast. It really was like training. It was instant.
Referring to his marksmanship training, yes.
He said it was like muscle memory.
He did say that.
He said it was his training coming out.
He did say that, yes.
One moment. No further questions.
Sergeant McLaughlin, just two questions. How many police stations or police barracks are in Keene?
So there's a state police barracks in Keene, so that's one. The Keene Police Department is two, and the Cheshire County Sheriff's Department is in Keene as well, so that's three.
And to the location where he was originally stopped by, or initially stopped by police, he passed right by your barracks, is that correct?
He even commented that he saw the sign for the state police barracks.
Okay. And he avoided that?
Yes.
Now, how many police stations between Keene and Concord?
A lot. You don't expect me to know how many, do you?
No, that
Okay,
many, right?
a lot.
You can't even judge.
And even from the Vermont border into New Hampshire, there's at least Chesterfield Police Department.
Okay. Did the defendant talk to you about whether he had a connection to Concord, New Hampshire?
No.
Now, everything in the defendant's statement, all of the words that he provided to you, that's what he told you, correct?
That's correct.
Anybody else tell you those words?
No.
No other questions?
Recross?
No, Your Honor.
Okay, thank you. Can Detective Sergeant McLaughlin be excused?
Yes, Your Honor.
Okay, thank you.
Thank you, Ron.
Your Honor, may I approach the monitor?
Certainly.
May I approach the monitor?
Your Honor, at this time, the state has no further witnesses and we would rest.
Bow, wow,
Okay.
wow. I mean, bow, wow, wow.
All right,
Woof,
thank you.
woof.
Okay,
I'm
members of the jury,
speechless.
at this
They just
time,
rested.
I know that we just started for the day, but we are going to be taking a break at this point. So I'm going
Not
to
sure why I barked there.
request again that you retire to the deliberation room. Please do not discuss any aspect of the case. Do not discuss it with any other member of the jury. If anybody does that, please report that to a court security officer. And thank you, and we'll resume as soon as we can. Okay?
All right.
I clearly have a dog in this fight. I don't know why barking was the first thing that came to my mind, but good morning, everyone. Happy Friday. Feels like a Monday a little bit. It feels like this could have been an email or at least done yesterday. You know, go an extra 2 minutes yesterday. It could have been done. No, but here we are anyway. Let's see if we got a JOA motion from the defense.
Scratch all that. Oh, that was terrible. I apologize.
It started like a boom and then a wow, and it ended in a bow. That was my only explanation for it. We're not hearing this motion. We should be. Come on, guys.
When are we going to break for lunch, Judge?
This is a Rule 29
No
motion.
rational trier of fact could find beyond a reasonable doubt the state has disproved the affirmative defense of others, and therefore the court must dismiss all 4 charges. Specifically, Dustin was justified when he shot Caitlin, and all charges must be dismissed. The state offered evidence that Caitlin died from a gunshot wound to the head, and that the gun that was shot was Dustin's, and was found in Dustin's car upon arrest. However, the state introduced the defendant's own statements through Detective McLaughlin, which offer enough evidence of justification, and so the burden shifts to the state to prove it was not justified. Dustin told the state in his interview how and why he was justified. Specifically, he described Caitlin refusing to leave his home. He said Caitlin was getting more and more aggressive. Caitlin told him she was going to take the kids away from him. Caitlin told him she was going to call the cops and have him arrested. Caitlin grabbed Elwin and was not letting go. She was again threatening to take the kids. Caitlin was saying she was going to take Valen and Elwin back to Minnesota. Dustin tried to grab Elwin and be like, hey, let go of Elwin. And Caitlin just wouldn't let go. Caitlin had Elwin in a bear hug, a 2-handed bear hug. Dustin tried to grab Elwin a couple of times. He couldn't pull that much because he did not want to hurt Elwin. Elwin was yelling. Elwin was crying. Caitlin was holding Elwin forcefully enough to cause her to cry. Dustin said he grabbed the gun, chambered it, and while grabbing Ellen, pulled her back and shot. He said it was immediate. He said it was super fast. He said, right when I shot, it was just immediately I grabbed Ellen. Dustin said, everything was so fast, it really was like finger snapping training. It was instant. He said it was like muscle memory. It was his training coming out. He said right when he shot, he grabbed Ellen, ran out of the house, put her in the car. He sat for a minute talking to Ellen. He said he was making sure that nothing had happened to her. He said he was checking to make sure she didn't have injuries. He said she didn't. He loaded the car up, got the kids in the car. He was thinking at some point I'm going to turn myself in, but first he was going to spend some time with his kids, and he drove toward Concord. New Hampshire 627-4, paragraph 2 says, a person is justified in using unlawful, deadly force against another person under 4 separate circumstances. And the defense argues that 3 of those 4 are applicable here. When he reasonably believes that such person is B, likely to use any unlawful deadly force against a person present while committing or attempting to commit a burglary. C, is committing or about to commit a kidnapping. Or D, is likely to use any unlawful force in the commission of a felony against the actor within the actor's dwelling. So here, paragraph B is met. Caitlin used force against Ellen when she restrained Ellen in her arms while committing a burglary. She entered or remained unlawfully in the building or occupied structure. She did not leave Dustin's apartment when he asked her multiple times. And she did not leave because she had the purpose to commit a crime. She entered and remained, refusing to leave Dustin's home while attempting to commit a number of crimes the court could find. Kidnapping, or 633-4, interference with custody. A person is guilty of a Class B felony if such person knowingly takes from the state or attempted interference with custody, attempts to take from this state or entices away from this state any child under the age of 18 or causes any such child to be taken from the state with the intent to detain or conceal such child from a parent. Caitlin was threatening to do so, she was attempting to do so, she was refusing to leave the home or release Ellen. Or the purpose to commit false imprisonment, or the purpose to commit false report to law enforcement by telling the police that Dustin did not have permission to bring Ellen to Minnesota, or to New Hampshire. Harassment, with the purpose to annoy or alarm another, communicates any matter containing or any threat to kidnap any person or to commit a violation of interference with custody. Stalking, purposely, knowingly, or recklessly engage in a course of conduct targeted at a specific person which would cause a reasonable person to fear for his personal safety or the safety of a member of that person's immediate family, and the person is actually placed in such fear. And the course of conduct would be restraining and yanking back Ellen. Theft by extortion. A person is guilty of theft as he obtains or she obtains or exercises control of the property of another by extortion and with a purpose to deprive him thereof. As used in Section 2, extortion occurs when a person threatens to A, cause physical harm in the future to the person threatened or to any other person or to property at any time, or B, subject the person threatened or any other person to physical confinement or restraint. Attempting to obtain Dustin's money, extortion would be confining Ellen. Theft by deception. A person commits theft if he obtains or exercises control over a property of another by deception with a purpose to deprive him thereof. Deception occurs when a person purposely creates or reinforces an impression which is false, in which that person does not believe to be true. Attempting to obtain Dustin's money, deception would be telling Berlin PD that he took Ellen without permission. So those are all under paragraph B, where she was committing a burglary. Paragraph C is also met, where the evidence shows she was committing or about to commit a kidnapping. Dustin told the investigators when she said she was taking the kids back to Minnesota to take them away from him.
evidence shows that she was about to commit a kidnapping by her behavior and her words. And paragraph D is met, where here Caitlin was using unlawful force against Elowen when she was restraining her in her arms, squeezing her while attempting to commit interference with custody in Dustin's home. So she was in his home, she was attempting to commit a felony level offense and using unlawful force. If the court disagrees with those above arguments, it can still consider the crimes of reckless conduct and endangering the welfare of a child. And the state has not provided sufficient evidence for a rational trier of fact to find guilt beyond a reasonable doubt with respect to either of those charges. Reckless conduct alleges that Mr. Duren recklessly engaged in conduct which placed another Elowen in danger of serious bodily injury by shooting Caitlin while holding Elowen. 2 reasons the court must dismiss for insufficient evidence. 1, the facts don't show beyond a reasonable doubt that Dustin was holding Elowen while shooting Caitlin. The only evidence the state presented is what Dustin told Sergeant McLaughlin and what Dustin said. Right when I shot, it was just immediately I grabbed Elowen. He grabbed the gun, chambered it, grabbed Elowen, pulled her back out of the way, and shot. The state alleges that this action was reckless, even though we have also heard from McLaughlin's interview of Dustin that he is an accomplished marksman, a Marine, that he's won awards for his proficient shooting, he knows how to use a gun. There was no evidence he was impaired, that he was using the gun recklessly around Elowen, that he pointed the gun at Elowen. The state, in its opening, focused on the statement that his acts were deliberate. Dustin carefully aimed the firearm. He purposely pulled Elowen out of the way. He made sure that she was not at risk. He aimed the firearm away from her.
It was deliberate.
We heard that the gun he used has many safety features and cannot accidentally discharge. In terms of the risk to Elowen, this is no different than if Dustin and a child were at a firing range and Dustin fired, not towards the child, but instead at a target. That would not be reckless. The presence of a child in the same general area that a gun that is fired is not, without evidence that the gun was aimed at or near her, rise to reckless conduct. And third, for the endangering welfare of a child complaint, Your Honor, the conduct or the evidence that the court has heard feels bad, but what the state alleges didn't happen, and what did happen is not a crime. In Ray NK, 169 New Hampshire 546 defines what endangering the welfare of a child means. A person is guilty of endangering the welfare of a child when he knowingly endangers the welfare of a child under 18 years of age by purposely violating a duty of care, protection, or support he owes to such child. So the state's required to prove 2 things: that Dustin knowingly endangered the welfare of Elowen, and 2, that he did so purposely by violating a duty of care owed to her. And so again, the evidence here is that Dustin grabbed Elowen from Caitlin and moved her out of the way while simultaneously firing 1 bullet in Caitlin's head. He said, "Right when I shot, it was just immediately I grabbed Elowen." He did not violate a duty of care. He acted out his duty to care, to save her from harm, to remove her from the situation.
I'm not buying any of this. I'm sorry.
There is no evidence Elowen was endangered. Evidence is sufficient to prove endangerment if it establishes, and again, this is from NK, in Ray NK, if it establishes that the offender engaged in behavior creating an actual and significant risk of injury to a child's welfare. The state didn't offer evidence of welfare beyond harm to the ear. So there was no evidence that there was any potential psychological harm or anything of that nature. There was no evidence that she was injured. She was complaining of her ear hurting. The doctor told us her pain was secondary to lateral noises. There was no evidence of perforated eardrum or trauma to the ear. There was no outward signs of trauma. Elowen appeared well-kept and well-nourished. That's what Dr. Robertson said. There was no evidence of the volume produced from the gunshot. We heard evidence
Could have
of
been
the
quiet,
amount of pressure
Judge.
it takes to pull a trigger,
That one might have been a silent
but
bullet.
no one testified how loud the gun was. And the state did not present evidence of how loud a Beretta 9mm pistol is when it's fired. And that's no different, Your Honor, I would argue, that when you take a child to a musical
daughter said it was
festival with
loud.
loud music without ear protection.
It's so different.
And also, as we know from the evidence that Sergeant McLaughlin provided on direct and again on cross, is that Dustin said, I can see where this is going of like, could it be that I'm endangering Ellen by what I did? And I would very much say no. And then Sergeant McLaughlin responded, yeah, just to kind of tighten that up a little bit more, you're an expert marksman of some sort in competition. So it's fair to say you knew you were not endangering Ellen. And Dustin responds, yes, I was not endangering Ellen. And to follow up, Your Honor, again, they have to prove the mental states of both knowingly endangering the welfare of a child and purposely violating a duty of care.
Rock concerts normally 90 to 120 decibels. Beretta 92 FS right around 160 decibels.
Okay, Attorney Spicer.
Thank you, Your Honor. They asked that the court deny the motion.
They're different.
In the light most favorable to the state, there has been sufficient evidence provided for a rational trier of fact to find each element of the offenses charged. I'll note for the court, as this court is aware, it's the defendant's burden at this stage of the proceedings. I don't believe that they have met that burden and shown that any of the charges should be dismissed. I will start with the murder charges. The defense argued that there has been evidence presented of self-defense through the defendant's statement. I would not agree with that. At this point, I'll make arguments, assuming that to be true, but I would state for the record, I don't believe that that's true. The defendant's statement established that he told Sergeant McLaughlin that he killed Caitlin Knapsaker very deliberately, that he did so because she refused to leave his apartment, that he did so after a day of arguments about things that they had been arguing by his own testimony for months and weeks. None of the statements that he claims that Caitlin made the day of the murder, that she was going to take the kids away from him, that she was going to call the police, are things that were new to him. By his own testimony, she had said similar or identical things to him before in other contexts, and at no point did he shoot her in the head. His testimony, I think, was pretty clear, certainly in the light most favorable to the state, that he killed her because she wouldn't leave. He wanted to put her and the kids in the car so that he could drive them to her Aunt Brenda's house. He was in the process of doing that by his own statement. He put Valen in the car seat and got her ready to go. He was trying to take Ellen in so that he could do the same thing, so that he could get her into the car and get Caitlin moving. Caitlin refused to let Ellen go, and she refused to leave. The clear import of the defendant's statements was that was why he killed her. And so, just for purposes of the record, I don't think this is disputed. With regard to second-degree murder, both the knowing and the reckless varieties, there has been sufficient evidence presented as to each element of those offenses. That the defendant caused Ms. Knapsaker's death, and that he did so knowingly, and in the alternative, recklessly, with extreme indifference to the value of human life. The defendant has admitted that he pointed his gun at Caitlin's head and fired it. He has admitted that he knew the bullet went straight through. He has admitted, in essence, that he was aware that his conduct would cause Caitlin's death by pointing a gun at her head and pulling the trigger, particularly in light of his statements about his own expertise and his own experience with marksmanship and handling of weapons. So I don't think there's any argument there. I didn't hear anything from the defense about this. I'd ask that you find that the state has satisfied the elements of knowing and reckless second-degree murder. Again, keeping in mind that there has to be some evidence of self-defense before self-defense that shifts and the burden moves to the state. Understanding that the state does not admit that that has happened here based on the evidence before us. Even if that is the case, there is sufficient evidence at this stage in the light most favorable to the state where the rational trier of fact could find for the state. The case law on this is somewhat convoluted, so I don't want to misstate the standard, but I'm citing State versus Pennock here, 168 New Hampshire 294 at 307. It's a 2015 case. At the sufficiency stage, the defendant must establish that no rational trier of fact, viewing all evidence and reasonable inferences therefrom in the light most favorable to the state, could have found beyond a reasonable doubt that the defendant did not act in self-defense. And that is an awkward formulation. But I would submit that there is certainly sufficient evidence before the jury for a rational trier of fact to find in the state's favor on that issue, that the defendant did not act in self-defense beyond a reasonable doubt. I'll talk now. I'll refer now to the facts. The defendant must actually and reasonably believe that he is acting in self-defense for any of the various forms of self-defense to come into play. He must actually believe it, and that belief must be reasonable. The facts here show the defendant did not believe he was acting in self-defense. The defendant shot and killed Caitlin. He then packed up several days' worth of clothes, got in his car, and began driving. He certainly told Sergeant McLaughlin, my plan all along was to turn myself in. He never, in fact, turned himself in. He was arrested at gunpoint and pulled out of his car. The defendant spoke for 2 hours, as we saw, with Sergeant McLaughlin. At no point in that statement did the defendant tell Sergeant McLaughlin, I acted in self-defense. At no point did he tell Sergeant McLaughlin, I did what I had to do. I didn't want to kill Caitlin, but I had to do it. Words to that effect. At no point did he say the word kidnapping. At no point did he say anything indicating he thought Caitlin was kidnapping the children. This kidnapping is a fabrication that the defense has presented here. The defendant himself did not believe it, and that's what the evidence shows, certainly in the light most favorable to the state. There is no evidence that the defendant believed it was necessary to use deadly force to defend himself or another. The defendant told Sergeant McLaughlin, when asked, that Caitlin did not threaten him, did not threaten Ellen physically. No physical harm threatened. The defendant's actions, I think, further, beyond what he told the police when he had an opportunity to tell them why he did what he did, and failed to say that he acted in defense, or acted in self-defense, or acted because he thought Caitlin was going to steal his kids, or acted because he thought he was never going to see them again, or that it was necessary to prevent these things. The defendant called his mother and told his mother, in effect, I shot Caitlin, you should probably call the police. He didn't tell his mother I had to do it. He didn't tell his mother she was going to kidnap the kids. He said, I shot Caitlin, or words to that effect, you should probably call the cops. In the light most favorable to the state, those are not the words of someone who believes that they have used deadly force in a justified manner. I'll go through the various forms of kidnapping. I'll put this on the record, Your Honor. Under State versus Monroe, and I don't have the site handy. Here it is. 173 New Hampshire 469. The defendant not only must provide an actual notice of defense in support of the defenses they intend to pursue, but there also has to be specific presentation of, or sufficient notice of the factual allegations supporting the defenses. With regard to burglary and all those other flavors of kidnapping beyond, flavors of self-defense beyond kidnapping, I don't believe that was done. Walking through each of the varieties of kidnapping in 627-4, starting first with 2A, I addressed that. There is no evidence that the defendant acted because he reasonably or actually believed it was necessary to prevent the use of deadly force against himself or anyone else. He told the detectives that. 627-4-2B, the The defense presented this court with a variety of crimes they claim that Caitlin could have committed or had the purpose to commit when she unlawfully remained inside of Mr. Duren's home. I can only imagine what the defense attorney would say if the state tried to charge someone in Caitlin's position with burglary, based on the statements and the facts and the circumstances in this case. I'm not going to address each of those crimes. I don't think it's necessary. I don't think the facts support them, and certainly not in the light most favorable to the state at this stage. There is sufficient evidence to show that the defendant did not actually believe Caitlin was committing a burglary, that he shot and killed her by shooting her in the head because he actually and reasonably believed that Caitlin was going to had a purpose to commit theft by deception or false imprisonment or anything along those lines. So at this stage, in the light most favorable to the state, there is not sufficient evidence here, or there's not a lack of evidence that would allow this court, on the state of the evidence as it is, to dismiss the murder charge because of the defense arguments. 2D, 627.4.2D, defense counsel misstated the law. Defense counsel stated that under 627.4.2D, well, I'll state, the law says that a person is justified in using deadly force upon another when they reasonably believe that a person is likely to use any unlawful force in the commission of a felony against the actor while inside the actor's dwelling. The actor in this case is the defendant. So what that law actually says is that the defendant would have had to believe that Caitlin was likely to use unlawful force in the commission of a felony against him. Defense counsel clearly claimed that he was going to use force against, that Caitlin was going to use force against Ellen. That is not what the law says. It says the actor, the defendant is the actor. So the court should reject that. There's no evidence to support that, and there's certainly not sufficient evidence that the state cannot defeat it, and that there's that no juror could find for the state on this issue. With regard to kidnapping, I'm going to ask the court to reference the arguments that we made in our pleading filed yesterday about the law. I can summarize them here. I don't want to get too far into the weeds, but to come back to the actual unreasonable belief, the court knows what the defendant said in that statement that was put into evidence. That is the evidence of what the defendant, at this point, actually believed happened inside that apartment. I'll note also that at this stage, credibility determinations with regard to witness testimony must weigh in favor of the state when they're equal. And the court can assess the credibility of the defendant's statements or different parts of the defendant's statements, taking into account that he is providing his account of what happened, his story of what he told the police about what happened. With regard to kidnapping, as we stated in our pleading, Ms. Nafziger legally could not kidnap her own child under 633(1)A. Could not do it. Based on the interplay of 633(1)A and 633(1) and 627.4(2)C, as we say in our motion, interference with custody is not a basis for the use of deadly force. That is what the defense is arguing. The defense is arguing that by telling the defendant or indicating that she wanted to take the children away from the defendant, they are claiming that that is a kidnapping. That is not something that legally Caitlin could do. And to find that would be to add interference with custody to the list, to the narrow circumscribed list of circumstances where the law allows the use of deadly force. And that should not be the case. And with regard to each of the different versions of kidnapping, at this stage, again, the defendant did not tell the police that he killed Caitlin because she was holding Ellen hostage. There was a reference to his training. The sergeant asked the defendant about if he had any sort of hostage training, and the defendant, it was somewhat difficult to see what he said or understand if he was giving an affirmative answer. he may have said, yeah, I had some sort of training. They would have covered that in some of his training. That was an opening for the defendant to say affirmatively and clearly, that's what I thought this was. This was a hostage situation. That's not what he did. He did not say that. So there is no evidence, certainly not evidence at this stage sufficient for dismissal, that the defendant actually and reasonably believed that there was a hostage situation and that is why he killed Caitlin. And I'll just add in here that ignorance of the law is not an excuse for the defense to claim at this point that, well, the defendant thought that Caitlin was committing a kidnapping in ignorance of the law, which says that what she was doing or what he said she was doing was not a kidnapping. The law very clearly says that's not an excuse. The fact that he doesn't know what the elements of kidnapping are, he is mistaken on what a kidnapping is in the state of New Hampshire, that is not an excuse. The defense argument is built upon the idea that ignorance of the law is an excuse, and this court should not agree with that. 633.1.1a is the ransom hostage situation. I'm not going to address that any further. 633.1b says that there's a kidnapping if someone confines a person to avoid apprehension by law enforcement. There's no evidence that that's what was happening here, and defense has not claimed that. 1c, to terrorize anyone. Defense has not made that argument. I don't think there's any evidence that Caitlin was confining Elowen by holding her in her arms for the purpose of terrorizing Elowen or terrorizing the defendant, causing him alarm or dismay.
The judge is giving all the not listening signs.
Would require that the victim Caitlin confined Elowen for the purpose of committing an offense against Elowen. That is not, there's no evidence that Caitlin was intending to hurt Elowen. And in fact, the defendant disproved that.
Waiting for him to finish, he's made his
decision. She was not
decision.
intending to harm Elowen. As Sergeant McLaughlin testified, the defendant told him Elowen was yelling, but the defendant said it was a combination of things. It was not just because Ms. Nafsiger was squeezing her or holding her so hard that she screamed. It was also because of the yelling. So I want to clear that up. So that would be the state's argument with regard to the two murder charges. The elements of those have been met. There is sufficient evidence for the jury to find the defendant guilty beyond reasonable doubt on knowing and second-degree murder charges. There has not been evidence of self-defense sufficient for the burden to shift at this stage for purposes of this argument. Notwithstanding that, there is sufficient evidence, or the state of the evidence at this point does not justify dismissing them on a self-defense ground because there is sufficient evidence for the jury or the rational trier of fact to find in the state's favor on the self-defense issue.
All right, he wraps up.
Moving to reckless conduct under 631.3. The elements of that are that the defendant engaged in conduct that either placed or may have placed another person in danger of a serious bodily injury, and that he did so recklessly with a deadly weapon as a firearm. In this case, the defendant, by his own admission, grabbed Elowen and then fired a gun at Elowen's mother while holding her so close that she complained instantly that her ears hurt. Reckless conduct does not require actual injury. It does not require evidence of actual trauma or actual diagnosis of injury. In this case, we do in fact have the testimony of a doctor who said she sustained an injury to her ear. That was what the doctor said. The defendant used a deadly weapon, and that deadly weapon was a firearm. The defense argument focused on the fact that the defendant is an expert marksman, and there's no way that he would have shot Elowen while he was busy shooting Elowen's mother. That may be true, but in light most favorable to the state, I think it is certainly reckless to shoot a gun that close to a small child while holding her essentially in the other arm. The defense actually presented two factual scenarios here, claiming that maybe Elowen was not in his arms, and that by saying that he grabbed Elowen and ran to the car, she was not somehow in his arms. If that is what they're saying the evidence shows, then Elowen is somewhere within the room, not in his arm, not confined, I think that actually adds to the state's case that she's somewhere at large while he's shooting a gun. It is not just the risk of a gunshot wound to Elwyn, however, it is a risk of any injury, including injuries to the ear or to Elwyn's hearing. There is testimony about that in the light most favorable to the state. The motion should be dismissed at this stage because there is sufficient evidence for the jury to find beyond reasonable doubt for the state.
Last charge? Are you done?
With regard to endangering the welfare of a child, again, there does not need to be actual injury for the defendant to be found guilty. And we are talking about injury to the welfare of a child, not physical injury. The cases on this crime that describe other versions of this where people have been convicted and those convictions have been held speak of situations involving, a caretaker getting high or drunk with a child in the car. Certainly while driving, but in other instances just getting drunk or falling asleep and becoming inaccessible while a child who is 2 or 4 years old is in the home and unsecured in a crib, walking around in the home where things could happen. Those are factual scenarios that have supported convictions for this crime. The evidence here shows that the defendant shot Elwyn's mother in front of her. Although he told the police that he didn't think she saw anything and he hoped she didn't, she told the doctor that mommy and daddy were fighting, daddy hurt mommy and me, and there was a lot of blood. In the light most favorable to the state, certainly it is clear that Elwyn knows what happened. Elwyn is aware that the defendant shot her mother in the head. She was in the room and she saw it. There does not need to be further testimony for there to be evidence sufficient at this stage that by shooting Caitlin in the head, the defendant endangered Elwyn's welfare. We are not claiming that he injured Elwyn beyond by shooting her with a gun. But when we're talking about endangering the welfare of a child, psychological injury or psychological welfare comes into play, emotional welfare, and that is what we're talking about here. There does not have to be evidence that Elwyn is actually in therapy or that she has actually been diagnosed with a mental health issue for it to be shown that the defendant endangered her welfare by doing things that he did. The dual standard here that the defense mentioned is the standard. Purposely violating a duty and knowingly endangered the welfare. There's a case on that addresses it pretty well. Defense cited INRI NK. That case, I think, discusses that standard in a good way. Also, State versus Bortner. I don't have the site, I just have the name, but BORTNER specifically discusses the interplay between knowing and purposeful, finds that is not a legal issue. And Bortner talks about a failure to act rather than an affirmative act. But
Cite on Bortner?
Excuse me?
You have a cite?
I don't have one. I
Okay.
apologize.
No.
I don't have it on me.
Thank you.
But BORTNER, it's 150 NH. I forgot to
Okay, no, thank you.
write down the end of it. Knowingly endanger and purposefully violate. I don't think that it is in dispute that by shooting Elwyn's mother in the head in front of her, that the defendant purposely violated the duty of care. He had to know, anyone in that situation would know, that that would seriously compromise and seriously risk danger to a child's welfare, psychologically and emotionally or otherwise. And purposeful violation of that duty of care that he owed to her. I think the knowingly engage in conduct speaks to the act. And we have already argued that the defendant acted knowingly.
Ms. Trout, welcome to the gallery. There we go. Now he's done.
Okay.
Just 1 second. No, then we're going to go back to the defense and they get the final word here.
Your Honor, 150 New Hampshire 504.
There's the citation.
504, thank you. Okay, thank you. Attorney King.
Just one comment, Your Honor. I think I said it in my motion that the state didn't offer any evidence of psychological injury or trauma or anything. It's speculation based on what it feels like. There was no evidence. And I'll leave it at that.
That's the slimiest argument I've
Thank
heard.
you. In response to that.
No, I don't think it's reasonable inference that shooting a child's mother in the head would endanger their welfare.
Okay. Okay, after considering the arguments made by counsel, after considering the evidence that has been produced at this stage of the proceedings, after considering the defense's arguments and the arguments from the state, I'm going to deny the defense motion to dismiss with respect to each of the counts. In construing this motion, the court must construe the evidence in the light most favorable to the state. If there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, if there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, the motion will be denied, citing State v. Wong, 138, New Hampshire 56, 1993, State v. Burke, 122, New Hampshire 565, 1982, and State v. Reed, 114, 377. Citing from Reed, in order to prevail, the defendant must show that the evidence viewed in its entirety, giving the state the benefit of all reasonable inferences, was insufficient to prove beyond a reasonable doubt that he was guilty of the crime charged. Here, the court does find that the state has produced evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, construing the evidence in the light most favorable to the state. The motion to dismiss is denied. A few comments with respect to the overall ruling. There was a couple points. First of all, I'm going to adopt the reasoning as articulated by the state with regard to the reasons why the court is denying the motion to dismiss.
You copy-paste the state.
With respect to the arguments from the state, there were a few times when the state inadvertently used the word testimony referring to Mr. Duren as opposed to using the phrase statements. There was a few times when Attorney Spicer used the word statements and a few times when he used the word testimony. Just to clarify, I'm considering the statement of Mr. Duren as referenced in the video and not any testimony, because that was not testimony under oath. So just to clarify, with respect to my reliance upon the arguments advanced by the state, anytime that the word testimony was used, I'm simply substituting the word statement for that as part of the overall argument. With respect to the individual arguments under 627.4 Roman numeral 2, at this point in the proceeding, I would find, once again, at this point in the proceeding, I would find that there has not been evidence relative to subparagraph A or D. There has been some evidence with respect to subparagraph C, and I will even indicate that there has been some evidence with respect to paragraph B, although that would be tenuous. To the extent that the burden has shifted with respect to C and arguably B, I would also find that no reasonable trier of fact could not have found that the defendant, could have found that the defendant did not act in self-defense if I'm arguing that double negative correctly under Pennick, I believe it is.
Yes.
Under Pennick, I'm trying to articulate the correct standard to deny the motion to dismiss, indicating that a reasonable jury could find that no rational jury under the circumstances could not find that the defendant acted in self-defense. It's a difficult standard relative to double and perhaps even triple negatives, but I'm denying the motion on that basis. So I believe that that takes care of the instant motion that is before the court. Attorney Kinney?
Yes, Your Honor, I think so.
Anything further?
No.
Okay.
Do you have a
Attorney Spicer,
defense?
anything further at this time? No? Okay.
Does the defense plan to put on a case?
I think he's indicating no as to that motion, Your Honor, but we do have an additional motion that I don't know if it's now that the court would like us to renew it.
Okay, one second. Attorney Kinney, any further motions at this point?
No, Your Honor.
Okay. Attorney Duren?
Your Honor, at this time, the state is renewing its objection to the proffered testimony or proposed testimony of Brenda Plumunden and or Shannon Spurgeon. The state notes that despite the court's indication that Ms. Spurgeon's testimony would be cumulative, she has been subpoenaed and is present along with Ms. Plumunden in order to be available for defense testimony. This objection is to any testimony of either of these witnesses related to any plan that they purportedly or reportedly discussed with Caitlin Nafziger. Your Honor, the court ruled following the state's initial motion to preclude this and following a hearing on that motion that you would allow the testimony, but you further held that Ms. Plumunda would only be able to testify as to her understanding of any such plan or discussion. You indicated that she must focus on the what rather than the why, without being able to testify as to any statements of Caitlin Nafziger or as to the reasoning behind the discussion or the plan. In making that determination, the court has found that apparently, based on some level of fairness argument or and cited to the court's reading of the defendant's transcript to provide evidence that the defendant was aware that there was a plan between Ms. Plumunda and Ms. Nafziger, and that supposedly that Ms. Plumunda will be testifying to that plan, but the court believed, based on its reading of the transcript and based on some level of a value of fairness, that Mr. Duren was somehow aware of this plan, which even defense has described as a secret plan that the defendant was unaware of. The state, as it's expressed in its motion for reconsideration, believes that there is no indication that the defendant had any knowledge of this plan and that he would need to have knowledge of such a plan, or at least of the desired result, in order for this information to be admissible. He would have to know that Ms. Plumunda was involved. He would have to know that the details of what they intended. In its ruling on the state's motion to reconsider, the court made it clear that you were allowing the use of this material in order for the defense to somehow impeach a statement made by the defendant. But the court indicated that it was a statement of the victim that would be impeached, specifically the victim saying she wasn't going to leave. But the state would point out that that victim's statement has only come to the court, been provided to the court through hearsay. It is the defendant's saying that the victim made these words or stated these words, and now the court is allowing the victim's own state of mind in to impeach the defendant's statement about what the victim said.
That's a good point.
And I hope that wasn't too confusing, but that's what we're left with. Your Honor, with respect to this, essentially the court has found that it would be fundamentally unfair to preclude defense from bringing up a plan that the defendant wasn't aware of to impeach a statement that he says the victim made while she was in his home and right before he shot her. So the court is allowing the testimony, but then further precluding the state from asking questions about the victim's actual state of mind in the 36 hours before her murder. The victim's state of mind is the basis upon which the defendant initially sought admission of this material, but by its own ruling, the court has said Ms. Plumunda can only testify to the what, not the why, and that the court has also precluded the state from talking about the reasoning behind the plan, the basis for the victim's state of mind, which is her statements about her fear, her concern, and the prior relationship that she had with the defendant that made such a plan necessary. Your Honor, the state is cognizant that the victim's state of mind includes potential 404B evidence. It doesn't make it any less admissible to encounter the admission of this plan. Under the arguments that the state has made, the state believes and continues to believe and believes that the evidence that has been provided thus far, including the evidence contained in the defendant's statement, means that the door has been opened. Defense counsel leaned in during their opening statement, indicating about the victim's aggression. They've argued it again in this motion. All evidence of the discussion between Ms. Plumunda and the victim, should the court be allowing any of it, all evidence should be admissible in order to provide the underlying rationale to cure any misleading advantage that the defendant will gain from this information. Again, the defendant had no knowledge of any plan, and this is something that they have now put forth as the actual basis for the defendant both having shot and killed Ms. Nafziger and for the support for these arguments that she was going to kidnap the children and now that she was going to be committing a burglary inside of the home. Your Honor, this is not proper impeachment. It's not proper impeachment of a statement of the victim. It is not proper admission of victim's state of mind evidence. It does not support or corroborate the defendant's state of mind at the time that he shot and killed Ms. Nafziger. Further, with the court striking any discussion or hearsay statements away from the testimony, the admission is not supported by Rule 806, which would be to attack Ms. Navziger's credibility as to the statement that the defendant told the police she made. Your Honor, in order for then existing state of mind, motive, intent, or plan to come in, this exception does not include a statement to prove a fact, remembered or believed. And that's exactly how this is being used in this instance. It's not only being used to show state of mind, defense is actually intending on relying on it to prove the underlying self-defense claim that they have. That is inappropriate use of state of mind, it is an inappropriate reason for its admission, and with the limitations currently provided, it provides a misleading advantage to the defense that cannot be cured unless the court, if this testimony is allowed, which the state still believes it should not be, but if the court is allowing any of it, it's still the state's position that the door is open and that the state should be allowed to elicit any and all testimony of Ms. Plumunden with respect to the planning of this situation. And so the state renews its objection, renews its motion to preclude, and renews its motion to reconsider.
Well, that was a strong argument. Let's hear the defense on this one.
Yes, Judge. I would reiterate all the arguments made in our objection, written objection, in our previous argument on this hearing, on this motion, and in our argument on the state's motion to reconsider, as well as the court's prior ruling. The court has ruled on this issue twice. There's been no new information, no change in the information available to the court when it made its ruling. A second motion to reconsider at this stage is not proper. The court's ruling is sound. This evidence is admissible under 8033, and because a reasonable inference can be drawn, as we've discussed at length previously, that Mr. Duren was aware of the plan. I'll note a couple of things. I think that the state is misciting 8033. 8033 allows a statement of the declarant's then existing state of mind, such as plan, but not including a statement of memory or belief to prove the fact remembered or believed. So if we were trying to introduce some statement about a past tense plan, something that like a statement that was made to Ms. Plumunden about events from months ago, then that would not be admissible under 8033. But because it's Ms. Plumunden's testimony about a current plan, it does apply under 8033. I'll just note a couple additional things. Again, this has been litigated at length. We've relied on the court's ruling. The court's ruling is sound. But the state argued a few moments ago that the kidnapping is a fabrication of the defense. I would expect they would argue that in closing, and the kidnapping is not a fabrication of the defense. Ms. Navziger had this plan. Ms. Plumunden has told that to detectives, to our investigator. She sent a text saying, "Need me to help plan a kidnapping." And so if the state's going to argue that kidnapping is a fabrication of the defense, that's certainly a problem when there's evidence that that's not the case. The other thing I'll note is the state, I'll rely largely on prior arguments on opening the door, but the state said the door has been opened because there's been evidence of Ms. Navziger's aggression. The state introduced that statement.
Is the victim.
The state pressed play on a video that had a statement about Ms. Navziger's statement, and the state cannot open its own door. So the court's prior ruling should stand.
Okay. Attorney Duren, any response?
It's the chivalry rule. Okay. You can't open your own door.
Satisfied with the record?
Yeah.
Relative to those issues?
Yes, Your Honor.
Okay. All right. I'm going to deny the state's motion to reconsider on that aspect. I've ruled several times on this matter.
We're going to hear from Brenda.
I did rule that Ms. Spurgeon would be inadmissible, would be excluded.
Yes, Your Honor. I'm going to be calling Brenda, so I'll talk to the court a little bit about that. Miss Brenda Plumunden is our witness, but Miss Spurgeon, Trooper Pratt, Arthur Booten are all here in case we need to call them for rebuttal purposes.
I don't see Trooper Pratt on the list.
I do have a request before Miss Plumunden comes in, Your Honor, but it's about her testimony.
Testifying?
And I'm just going over my notes relative to the state's.
Sounds like he will not be taking the stand. Brenda Plamondon, Plamondon, is the aunt that drove the victim to meet with the defendant, and that's where the defendant said he wanted her to go back to, 3 hours away. Brenda was also the one that was involved
again, I'm going to
in this
restate
plan.
part of the basis for my ruling is I believe that the state, in introducing the statement of Mr. Duren through Sergeant McLaughlin, it is clear that at several points in that statement, Mr. Duren referenced a plan. He wasn't sure of what was happening. He articulated several times, and I recognize that he was offering the statement to law enforcement at the time, after he had a period of time between the event in question and the time of his interview. Not a lot of time, but there was some time. I recognize that he was offering the statement and that he indicated to law enforcement that he was asking what was the plan as it relates to Ms. Nafziger being retrieved, so to speak, from his apartment in Berlin. In other words, was he going to bring her back to Hampton? Was someone else going to pick her up? There was a number of times in which Mr. Duren was asking what was happening to Ms. Nafziger, according to his version of events. And based upon the defense argument relative to the introduction of Ms. Plamondon, am I pronouncing it correctly? Plamondon?
I believe so.
Okay, I apologize if I mispronounce. But according to that, I'm allowing the defendant to bring her in to testify relative to the contours of that plan, not with respect to any individual hearsay statements of Ms. Nafziger, and not with respect to the reasons for it. I agree with the defendant relative to the 404B motion that was previously ruled upon as it relates to any conduct that is not currently before the court, and I don't think that the door has been opened. I agree with Attorney Kettles as it relates to the fact that the state cannot open the door itself. Whether that happens during the rest of the trial remains to be seen. That'll be subject to further discussion as we move forward. But as of right now, the purposes and the reasons behind my ruling still stand. Anything further, Attorney Durand, on those points?
No, Your Honor.
Okay. Attorney Kitty.
Yes, Your Honor, thank you. So, Ms. Plamondon is here. Well, I believe she is. I haven't seen her today, but okay. And she is prepared to testify. We expect her to be a hostile witness. This is difficult, I'm sure. Her family is here, has been here. And we are very concerned that
she will open the door
something
intentionally.
might be said to cause a mistrial. So I'm asking for two things. Number one, for the court to have a colloquy with her outside the presence of the jury to just let her know she's answering the questions that are asked and not going into details. Because I think there will be a natural desire to try to explain things. And I would like to be able to lead a very tight and specific questions to produce the testimony that you have deemed to be admissible. I will note that the state got to do that with Carolyn Campbell. We want to avoid a mistrial, and I think the chances are high that she will say something. And I haven't been able to talk to her about that, but I also don't know how much weight she'll give me saying those things. I think it would be better to come from the court.
Okay, thank you.
Your Honor, it's unclear to the state whether defense has actually spoken to or prepared Ms. Plamondon for trial testimony at all, let alone where this indication is that she's a hostile witness. Ms. Plamondon is here. She was provided with, I guess, Mr. Booten's report as far as I saw. She described it as a transcript when we were told what she received. That's all I know. It looked like Mr. Booten's report. I haven't spoken with Ms. Plamondon because she's a sequestered witness, but she's being called by defense. I'm not sure that they've spoken to her. It became clear during a chambers conference yesterday that they hadn't spoken to her about sequestration. And so I don't know how we're at the point now of saying she's going to be hostile. Defense counsel is calling her as a witness. They didn't take an opportunity to prepare her, and now they're attempting to say that she's hostile. There's no indication of that at this time, Your Honor. She's not a party to the case. Sure, her family is here. Yes, she has a relationship. Her niece was murdered, but that doesn't mean that she's a hostile witness in any way, shape, or form. I understand the defendant's concern, and I will note that the state was ordered to lead Ms. Campbell through testimony because of objections made by defense. Ms. Campbell wasn't a hostile witness in any way, shape, or form.
Right.
Defense wanted to limit her testimony because they didn't want her talking about hearsay statements that, again, the state doesn't believe were inadmissible hearsay. They were her descriptions of her actions.
How have we gone this far today without a sidebar?
There's no indication that Ms. Plumunden is hostile. There's no indication of anything at this point. She's just a subpoenaed witness that hasn't been prepared by the people calling her.
Your Honor, first, we got a Zwicker letter the other day from the state, so someone talked to her, but the consideration...
If I may interrupt really quickly, the Zwicker letter says Ms. Plumunden was asked 2 questions and provided the answers to those 2 specific questions, and that is it.
Okay, so you talked to her, though.
2 questions. What was Valen's date of birth? I do not know. Was Caitlin Nafziger breastfeeding? No. Those were the questions.
611-2, C2.
That's what I'm looking at.
Okay. When a party calls a hostile witness an adverse party or a witness identified with an adverse party. And it is true that I have not specifically talked to Ms. Plumunden about her testimony. I have provided her the recording of her 2 statements that she gave to the police on March 1st and March 15th. I have provided her the transcripts of both of those calls. I have given her the report that Arthur Booten typed up of his interview with her. Those are what she has. I have not talked to her. I have given her the opportunity to ask me questions. But based on what she told the police on March 1st and March 15th and Arthur Booten, and the things that she said about the defendant and the reasons why the plan existed, it's very prejudicial. It will lead to a mistrial if it gets blurted out, Your Honor. So for that, there's 2 reasons that I'm asking the court to give a colloquy to her and allow us to leave so we can avoid that. And it would be great if she doesn't come off as a hostile witness and just gives, and would give us the information. I just think the risk is very high, and to avoid future litigation, I am asking that we be allowed to do that.
The court has an interest.
Understanding that there's issues relative to the preparation of witnesses and disclosures of various information, understanding that, Attorney Duren, do you have any specific response to those 2 specific requests by the defendant?
Your Honor, I'll defer to the court.
Okay, all right, thank you. Okay, I think under the circumstances, I'm going to grant the defendant's motion to allow leading questions relative to this witness, and I will conduct a brief colloquy with her because of the reasons stated by defense counsel relative to those issues. The colloquy is going to be focused upon her understanding that she has been number one, that she has been subpoenaed here, and that she's going to be asked questions, and that she's instructed to, is she prepared to answer the question that she is asked? Are you prepared to answer the question that you are asked? And are you prepared to limit your testimony to the question that was asked and not to volunteer further information? Is that sufficient, Attorney Kenny?
I don't know why we're doing the colloquy and granting the motion to lead. If she answers appropriately to both questions in the colloquy.
And Jared, I think it would also make sense to
lead?
instruct her specifically in accordance with your order that
Not to
we're
mention.
talking about the what of the plan and not the why of the plan.
Ooh, there are allegations. There must be allegations. Why she needs to take the kids from him.
And finally,
Why she has to
that
kidnap
she's not to testify about statements allegedly made by Caitlin. That she can testify as to her perception her understanding of what her understanding.
Just a question for clarification, and why the state has asked so many times for the motion to be reconsidered. Is Ms. Plumundon then allowed to testify to the factual result of a statement that is a hearsay statement of Ms. Nafziger, or is she only allowed to testify to her portion of the plan?
Her understanding of what was going to happen.
And doesn't that include hearsay statements of Ms. Nafziger?
And I've already ruled that relates to her understanding as to that, not relative to indirect hearsay. But she can't testify as to what Caitlin said to her, but she can testify as to what she understood the plan to be.
Wow. State's not liking this one. That's basically everything defense wants here. They get the testimony in that the kids were going to be kidnapped.
No, Your Honor.
By Caitlin and Brenda.
Trying to read anything further right now?
No, Your Honor.
Okay.
But not
10-minute
allowing
break.
why Brenda and Caitlin felt it necessary to kidnap the kids and get them away from the defendant. Because that evidence is so prejudicial, it would immediately cause a mistrial. There are clearly allegations against the defendant that might justify the kidnapping. This is a fine line they're parsing. As family members step out here, I don't know if this will work. I don't know if the defendant will do it. This could be a mistrial if she blurts it out. Even if she says, "Yeah, I'm going to do it," and then she blurts it out. The defense wants yes and no answers only. That's what they want. Yes or no. Nothing open-ended. No, definitely no narrative. If there's a factual number, like a date that needs to be offered, just the date. Nothing beyond that. Because this is going to be very. It's a tightrope, right? The court has an interest in not having a mistrial. There's a financial interest to the taxpayer. There's an interest to justice. They want the prosecution is for the crimes alleged and for nothing else. You can't have some outside information that this guy is a member of this awful group come into court. If it would prejudice the jury and say, well, if he's a member of that group, then clearly he's guilty of those things because that's just what that group does. I'm just making up an example there. I don't know what the facts are or what the allegations are regarding the reason behind the attempted or the plan to get the daughters away from the husband. Or not the husband, the dad. All right. Yeah, and let's not speculate in chat. It gets too close to areas that get really problematic for YouTube and for legal reasons. Hope she blurts it out. I'm starting to get some bad feelings about this guy. This could be what the defense wants, a mistrial. I don't think they do. I don't know how they could have a better trial than the one they've had, right? I think defense has won on many, many counts, on many, many sidebars. Defense has won and gotten what they wanted. This has basically gone the way they envisioned it going. So unless they've got a really bad feeling about the jury, I don't know how this would happen. They have to ask their questions so carefully, and I know experienced lawyers will do that, but craft the questions very carefully with an instruction, yes or no, and be very quick with the objections, because if she blurts something out, it could be game over right now. Friday morning fireworks are happening for sure. I was looking at the defense's witness list. They, as of earlier this month, about 3 weeks ago, they filed an amended defendant's witness list. They had Roger Pittman, MD, so a doctor on there. Arthur Bottine, who's been mentioned as somebody they might have for rebuttal. Brenda, the aunt, Then Shannon Spurgeon was on here. The judge said Shannon's not going to be allowed to come in. And they also had Catherine Gann on here, but they haven't mentioned her at all. They said Brenda is their witness. That's who they've got. But they did mention today another officer who was present that may be called as rebuttal as well. So Brenda might be their only witness, their one witness, and then in rebuttal, if needed, two others, which I guess would be a surrebuttal, right? Because the state gets rebuttal. Oh. What happens if she tells the judge she's not willing to only answer the questions asked? She could be held in contempt because the judge can order her to do it. This is an appropriate order for the judge to order them to do that. And if she says, I won't do that, that's contempt. So yes, she could be literally go to jail for refusing to follow the orders in courtroom, or face a fine or something like that. It hinders justice, and the way the law works, the judge gets to make the calls on the balls and the strikes and how things happen in the courtroom. And if you refuse to play by those rules, as a subpoenaed witness required to be there, required because your testimony is crucial to the administration of justice, right? For the defendant to have a fair trial, if you refuse to do that, you're hindering justice, and you'll be found in contempt. How would be a hostile witness in this case? How does she help the defense? Susan, imagine this. Imagine they call Brenda up to the stand, swear her in under oath, and say, look, you're only supposed to answer the questions I ask you. And when I ask for a yes or no question, you can answer it with a yes or no question. That's it. And if you can't answer it, just tell me you can't answer it, but you're not allowed to volunteer any other information. That's basically what she's going to be told. And then they stand up and they say, Brenda, is it true that you and Caitlin had a plan to kidnap the children without the defendant knowing to get them away from him? And she says, yes. Is it true that you were trying to do this in secret and behind his back without his permission? Yes. No further questions. That would help the defense, because now you've got a situation where it looks like the defendant discovered this kidnapping plot, and he was, I still don't think it just justifies murder, but anyway, not kidnap. Right? The judge still has to rule on this, right? He has to say whether or not a parent with legal rights to the children can, in fact, kidnap their kids, and I don't think they can. Can she plead the fifth? I guess if they say kidnap, yes, right? Because then the defense is alleging that she was about to commit a crime, and you can't be forced to testify against yourself or to implicate yourself in a crime from the stand under oath, unless there's some situations at play with an agreement with the prosecution. Anyway. If they say kidnap, I would say I plead the fifth. And that would cause a mistrial. Because you can't plead the fifth on the stand either. She's not the parent. That's the issue. She's not the parent. This could be a mess every which way. I'm not sure how this is going to go down, but I'm sure the tensions are going to be high here in a little bit. Oh, man. No, Bree, you haven't missed the witness. We've basically, the state rested. We got a couple questions from the detective by the defense. They finished. That witness was released, and now the state has rested. The judgment of acquittal was argued quite thoroughly by both sides, and it was shot down quite thoroughly by the judge. So that was not granted in any aspect. And now we've got defense starting their case in chief. The jury's going to be brought in to hear this new witness. The one witness we're going to hear from is Brenda, who is the aunt who drove Caitlin and Elwyn to the restaurant where they met, and then they drove to the defendant's house. She has some knowledge about the relationship between the victim and the defendant and the children, and the plan that was potentially at play here involving taking the children away from the defendant. It is her aunt, yes. And all the families here in court to watch. I think it's spicy because apparently back in chambers earlier this week, we discovered that Brenda had not been told about sequestration, which means she might have been oblivious to the fact that she was not supposed to talk to people in the case, follow the case, read about the case, watch it on TV, or, ask questions about, there's a million things. So it is about to get spicy on a Friday. Oh, I'm so not moving. This is going to be spicy. It could be a fizzle, right? Where there's tension under the surface, but just nothing comes to head because it's operated properly. And I think that's what the judge would like. He would like her to come up, and as frustrated as she is about the situation, and as long as she takes to think about the answer before she says yes or no, as long as she doesn't volunteer something that would be, explosive, or plead the fifth on the stand, justice can move forward. Oh. Children did temporarily go to the aunt after shooting. There might be some questions there, Northwest, by the state in rebuttal if that comes up, or in cross-examination by the state to ask what they heard from the older daughter. What was the impact? Was there psychological damage from that? Nexus Lexus, curious about the family court jurisdiction here, as it seems to me to have not been properly vetted with him moving to New Hampshire with the older daughter. Nexus Lexus, there was no court situation. There was no proceeding. There was no marriage. There was no divorce. There was no annulment. They were boyfriend, girlfriend who had kids together and decided to move to different places. That's all there was. So it was by mutual agreement. If anything, there was no court weighing in at all. Oh, Brenda takes the stand. Seriously? They're going to put her up there ahead of the witness? They're not going to make her walk in like everybody else did? Well, I guess this is the colloquy first, so I guess that makes sense. She might be asked to leave and then walk in when the jurors are present. So the judge should come out, ask the questions about Brenda, put her under oath, ask the questions, and then once he's satisfied with the answers, possibly either dismiss her if he wants that visual of the jury shouldn't know that something happened with her right before they came in. But you have the children now. The grandparents share them on both sides. I hope Brenda doesn't cause a mistrial. I want full-on snark and feisty. Lizzie, you're casting your vote. They were never married. You're right. I keep saying husband because, that's typically what we see. But I don't think they were even common law. How long were they together? I don't know what it is. Was it 4 years they were together? Sounds like I made it just in time. You are here in time. We're just waiting for the judge to come in. And of course, we need the prosecution as well. And then we'll be ready. They just brought their pots and pans together. That's one way to describe it. How hot will it get today? It could be. Literally, we have the components at play for a mistrial, which is about as spicy as court can get, because things go off the rails so fast that it just ruins the whole process. So it could be that spicy. I don't think it will. They've taken precautions. The judge is going to take some precautions. Defense with the granting of the rule, the granting of the motion by the defense to treat the witness, even though it's their own witness, as a hostile witness. It will allow them to lead, which means you can ask yes or no questions. You can ask questions that suggest the answer, and you just have to say yes or no. So they'll be able to lead, which normally if you call a witness, you sort of have to elicit testimony and say, what happened on that night? Or what do you remember about what did you observe about the type of relationship that they had? And she's like, well, it was, and she could speculate. Here they're going to say, is it true that the defendant and the victim argued about money a lot. And the answer would be yes or no. So 7 years in Pennsylvania for common law. Is the spicy meter on deck? I have not got the spicy meter working. It requires an iPad, which I currently don't have worked into my setup. All the iPads are in possession of Mrs. R.A. For school, so, and the kids. So I have the computer, she has the iPads. I'd like to see some text messages between the cat and the defendant. You know, there must be some. I think they were mentioned a couple times. Spicy meter has a 4-hour startup time. Greeners. Tax write-off for new tablet. I'd rather get a tax write-off for a new encoder. That's what I'm working towards right now. Take the burden off my switcher. It runs too hot. So you might need another muffin for this. I've had 2 already. I think that's my limit this morning. Let's see. Lots of great questions here. I think the defense is getting away with one on this. They sure are getting what they want, but at least as far as how things will proceed, they're getting the procedures in the way they want them. But how they actually turn out might not be what they want. This could be anyone's game here. Because both sides get to lead. When Cross gets up, they get to lead as well. So the only problem is if the state gets up and Cross examines the witness, defendants here, we can start soon. They can't open their own door. Tell us what you are not allowed to say. They can't do that. They can only ask questions that elicit legal responses, unpermitted responses, according to the judge's rules. If the defense asks a question that includes or incorporates something in it that opens the door, then they'd be allowed to. So the defense has to be very, very careful. I'm sure they probably have each of their questions written out word for word, and they've analyzed each one of them before they do this. And it probably won't be incredibly lengthy testimony either. How could it be a mistrial if you admitted to the crime?
Good morning. Thank you. Please
It's
proceed.
not that simple. The mistrial is if prejudicial information comes before the court, before the jury. That's not you. The jury's not here right now. You can see the clock just above the TV. Do you see it up there? There's the judge. We're close to him now.
Okay, we're back on the record outside the presence of the jury. Good morning, Ms. Plomondon. Am I pronouncing that correctly?
Yes.
Okay. First thing, Ms. Plomondon, if I could have you raise your right hand, please. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Yes.
Okay, thank you. Can I ask you to please spell your last name for the record, please?
Plamondon.
Okay, thank you. Again, thank you for being here. I understand it's under subpoena. Have you spoken with Attorney Kinney about the scope of your testimony?
No.
Okay. Ms. Plomondon, I am allowing the defense attorney to call you as a witness in this matter, but I have placed significant limits on the scope of your testimony. Okay? And has anybody told you that?
The defense attorneys just let me know that a minute ago.
Okay, all right. I'm going to go over that with you now in an effort to just make sure that we're on the same page before the jury comes back in.
Okay.
What if she blurts it out here in this? So I can't talk about,
boom. When Attorney Kinney, the lawyer for the defendant, when Attorney Kinney asks you a question, are you prepared to answer the question that was asked by Attorney Kinney?
Yes.
And when you answer her questions, are you prepared when testifying to not volunteer further information other than what you were asked about?
Yes.
Okay, thank you. Now, I want to also let you know that the state will have the opportunity, when Attorney Kinney is done, the attorneys for the state will have the opportunity to ask you questions as well. So that may clarify some of what you are asked by Attorney Kinney, but they will be operating under the same orders and rules that I have put in place relative to what they can and can't ask you. So that it's not just Attorney Kinney asking you questions. The state will have the right to ask you questions as well, okay?
Okay.
Okay. And Ms. Plumondon, the questions are going to be based upon what you knew at certain points in time, okay? They're not going to be based on why you knew them. In other words, it's not based upon what Caitlin told you or why certain things were being done. It is limited to what you knew at the time.
Okay.
Okay, in other words, your knowledge as to what was happening at certain points in time. That is what your anticipated testimony will be, at least with respect to the questions being asked by Attorney Kinney.
Okay.
Okay?
If she had direct knowledge, that still could be a
It will
problem.
be about what you understood, your personal understanding as to any plan that you might have had with Caitlin.
Okay.
Okay? It doesn't include Caitlin's specific statements to you as much as it is what you understood the plan to be.
Okay.
Okay? In other words, it's limited to your understanding at certain points in time. And I understand that it's difficult on many levels. I'm simply going over what the court's expectations are at this time. Do you have any questions of me, ma'am?
No, I understand.
Okay. And at this point, Attorney Kinney, any further comments or inquiry by the court that you would request?
No, none, Your Honor.
Okay. Any from the state at this time, Attorney Duren?
Nothing.
Okay. So I'm going to bring the jury in, and once again, if you have any questions of me, I realize this is a difficult process. If you have any questions of me, we can try to go over them now. I'll give you just a moment.
If there's a word or something that doesn't fit, is it just a no answer then? If
Just answer honestly. Answer honestly. Answer the question that Attorney Kinney or the attorneys from the state ask you.
That's a good question.
Just answer honestly to the best of your ability and to the best of your understanding as to what you understood at the time relative to any plan with Caitlin.
Okay.
Okay? I appreciate your ability to follow the court's instructions. Okay? Thank you.
She knows the defense.
Anything further? Okay.
She knows the defense is going to ask questions that are phrased in such a way to make it look better for the defendant. That's why she said, if there's a word, meaning if there's a word in the question that's asked of me, and it's not quite right, does that make it a no? So she knows she's going to be asked questions that make it seem a little bit different, that paint the situation in a light most favorable to the defendant. So, wishing her good luck on this one. This could not be fun, obviously, for a million different reasons. But this could get spicy really quickly.
Again, sure. Thank you.
Judge, I think, indicated he's going to swear her in again in the jury's presence.
All rise for the honorable jury. Cook County Superior Court is now in session. The Honorable Jonathan S. Frizzell presiding.
Okay, thank you. Please be seated. Ms. Plumondon, if I could have you raise your right hand. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
Okay. If I could have you state your name, please, and spell your last name for the record.
Brenda Plumondon, Plamondon.
Thank you.
Good morning, Ms. Plumondon. I just have a few questions for you.
They're written out.
You live in New Hampshire?
Yes.
Okay. And you have 2 children?
3.
3 children. And Caitlin Nafziger was your niece by marriage?
Yes.
Okay. And Elwyn and Valen are her daughters?
Yes.
They never lived with you though, correct?
No.
In early of 2024, Caitlin reached out to you about coming to visit,
Yes,
and she didn't give you much detail about her visit at that point, right?
yes.
So yes, she did not give you detail?
She did not give me much detail.
Okay, thank you. And later February, she reached out again with information that she was going to come to New Hampshire.
Yes,
Okay. And you knew that she had a plane ticket to Boston, correct?
yes,
And that she was bringing the baby Valen with her, correct?
yes,
But you didn't know where she was going to stay, right? Before she got to Boston?
yes, that's true.
Okay. Or if she needed to borrow a car, right?
Right, I had offered.
You had offered, but you weren't sure. She never responded yes or no, right?
True.
Okay. But Caitlin and Valen did come to Boston in late February 2024, correct?
Yes,
And
Defense told her she can only say yes or no.
they stayed
Calling that.
with you the first night they arrived
yes,
in Hampton?
yes,
Okay. And you and Caitlin and Valen stayed the night in Hampton. Was anyone else there?
yes,
Is that Shannon
yes. And my husband, Mark.
and your husband, Mark? Shannon is your friend?
Yes,
You can cut the air
So-
with a knife here. This is interesting.
That night at your home was the first time you really got to talk to Caitlin about her visit to New Hampshire, correct?
yes,
Okay. And that Caitlin was there, her plan was to go up and get Elowen and go back with both kids to Minnesota, correct?
yes,
Okay. And so you and Shannon and Caitlin talked about how that plan would play out, correct?
yes,
Okay. And you knew that Caitlin had a return ticket to Minnesota, correct?
yes,
And you would offer to pay for Elowen's ticket back?
yes,
Okay. So the plan was that Caitlin and Vela would go up to Dustin's in Berlin and study his habits, right?
Objection.
no. Sorry.
Roger?
Little side from the judge. Sidebar number 1 for the day. We're going to take it up to 36 on the counter. Made it all this way without a sidebar today, which was amazing. 36 it is. I get the feel that when this witness said the defense just talked to me and explained it to me, that when the defense explained it, they said, I'm going to ask you direct questions and you need to answer either yes or no, which is not necessarily true. If it's a yes or no question, you have to answer yes or no when the judge orders that. But it feels like she's limited to simply acknowledging or denying every statement or question made by the defense here. So hopefully she can break out of that a little bit. It's possible to do this without ticking off the judge or being, you basically rephrase the question and say, and you offered to pay for Elowen's ticket. I did offer to pay for her ticket. Okay, that's an affirmative. It lets you speak a little bit more. It might give you a little leeway, and you might be able to say something that we all want to hear.
So, Ms. London, the plan was for you, if you had not heard from Caitlin on Saturday, you were going to go to Berlin and wait at a restaurant to leave with her and the kids, correct?
No.
Okay, so we can ask about the plan, obviously.
You spoke to the police back in March of 2024 about this case, correct?
Yes.
Okay, and that was a recorded phone call that you gave them?
Yes.
And you agreed to be recorded?
Yes.
And you told them everything that you knew at the time, correct?
Yes.
And you didn't leave anything out?
To the best of my knowledge.
Okay. And you had a chance to look at the transcript of that recording, correct?
Yes.
Okay. And I'm going to show you page 7 of your transcript. Where you say line 9.
I assume it's being used to refresh your recollection.
I'm impeaching her, Your Honor.
Okay.
I'm impeaching my own witness. Objection. Approach 37. Your Honor. The judge is like, what are you doing with the witness? I'm impeaching my witness, Your Honor. All right. That's one way to start. I have one witness and I'm going to impeach her. We live here now. Oh my goodness. The state subjected to improper impeachment. The question immediately before this by the defense was basically you spoke to the police and you made a statement and you didn't leave anything out. She's like, to the best of my knowledge. Then comes this. So clearly you left something out. You know, you didn't talk about the plan. What? I don't know what it is, but the state doesn't like the way this is going down. We called one witness to impeach her, but we need her evidence to support. Think this through. We need her evidence to support the defendant being right in stopping the kidnapping, right? We need that part to come in, but right now we're going to prove to the jury that she lies. That she lies. This is so bad. Oh man. They haven't got to the good part yet. So go ahead and tick her off. Make her look like a liar in front of her family and friends, and then see how questioning goes. This is. I've never heard of somebody impeaching their own witness. Their only witness. Defendant not looking at the witness. He's got something very important to read. Cameron played with MegaZoom. I can tell you why he's doing it. First of all, he's used to being in a multi-camera shoot or a news situation where you set up the camera, frame the shot, get the focus, and then capture the media. So this is most likely somebody who's in the news or live production realm. The best way to get a good focus is to zoom all the way in, get that crisp focus, then zoom out and frame your shot. And as long as your what's called back focus is adjusted properly, then focus doesn't change as you zoom. If the back focus isn't adjusted right, then it doesn't help at all, and it gets blurry when you zoom out again. And there's a fancy little chart with lots of little fine points and lines in black and white on it that helps you adjust back focus. I had to do it once live in a basketball game. It's not easy, especially without the right equipment. It is very sensitive too. Long sidebar for number 37. I think she's allowed to answer more than yes or no. Oh, here we go. Let's see how this goes. See if the question changes. Oh, she's not being impeached. Further questions.
Did you you were able to review the transcript of your interview?
Yes.
Okay. And was it a fair? And does it look like this? Does the copy that you were given look like this?
What is this defense exhibit? What?
ID D.
Thank you.
I don't know. It was an email.
Okay. Well, why don't you take a look at that and let me know if that looks like the item you reviewed.
Yes.
And is that a fair and accurate transcript of what you told the troopers in March of 2015, March 15, 2024?
Some of it was mislabeled of what Shannon said and what I said.
Okay. And so I also have clips. Were you able to listen to the video?
No.
Okay. So, Your Honor, can we approach?
Yes. 38. Here we go. Now, the defense is doubling down. They're going to possibly even introduce video clips to impeach now. They've laid a little more foundation. Obviously, they jumped the gun a little bit on the impeaching, let's put it that way. I think they still haven't really got the statement out of her to impeach, other than you didn't leave anything out. This is funny. Another video might be coming up. It's possible that she did not tell the police that they planned to take the removal of the children, right? It's possible she didn't tell that to the police in her first statement. And then when the police are doing the investigation, they find on the victim's phone these text messages about it, and then it comes up. So that might be the impeachment we're going for.
Okay, Ms. Clement, please review page 7, lines 7 to 18, and then I'll ask you questions again of ID, defendant's ID, Exhibit D.
Defendant's ID D, not double D, just D. There are two Ds together, but the first part is part of the ID. Okay, she's been directed to a specific point. Yeah, you can call a witness and impeach them, but it seems funny that you're only calling one witness, and you need her testimony to support your defense, and you impeach them. Usually there would be like additional witnesses or corroborated witnesses.
So again, that the plan was to go to Berlin and wait for Caitlin and the girls to come meet you at a restaurant or somewhere and take them back to the airport.
No.
Okay, so can you tell us what the plan was?
Here we go. Open. It's open.
That we were waiting for Caitlin to call us and tell us how she needed a ride, and that we would meet her wherever we needed to meet her. And if by Saturday we hadn't heard from her, that we were just going to go to Berlin and wait to hear from her so that we would be closer and ready.
And the plan was to get them back to Minnesota, all three, Caitlin, Valen, and Elowen, as quickly as possible.
Yes.
The next
The impeachment
day,
was the piece of evidence they need.
after that plan was discussed, you offered to drive Caitlin and Valen up to meet Dustin, correct?
Kind of.
Okay. Did you drive her up to Ossipee?
Yes.
Okay. And you drove with Shannon, Caitlin, and Valen, correct?
Yes.
Okay. And you drove Caitlin and Valen to the designated meeting place, which was a restaurant in Ospey, correct?
Yes.
Okay. And Caitlin brought a suitcase with her, correct?
Yes.
She had a bag of like wet laundry because there was an issue with the dryer.
Yes.
Okay. But she did leave behind other things, right? Like her backpack,
Yes.
kids' birth certificates.
Yes.
Would you like a break?
Okay.
Okay. I only have a few more questions. You didn't see Dustin or Ellen when you dropped Caitlin Valen off, right?
No.
And after you dropped them off, you called Caitlin's mom to tell her what the plan was, right?
No.
Okay, you called folks though to talk to them?
Yes.
Okay. Those folks being her mom
Yes.
and her dad, Rob?
Yes.
Okay. I don't have any more questions, thank you.
Wow. So the impeachment is the only way they could get the testimony they needed. That makes sense now. That there was a plan to pick up Caitlin and the kids. Defense has to tread on thin ice here. Haven't been given a lot to work with. Or the state has to tread on thin ice. Haven't been given a lot to work with by the defense. It was very narrow questioning.
You're welcome, sir. Okay?
Yep.
There's some water there. Do you have some?
Yep.
Okay. Do you need to take a minute?
Nope, I'm okay.
Okay. Ms. Plumunden, you live in Hampton, New Hampshire, correct?
Yes.
How long of a drive did you have to come to court?
I don't know, like 2.5 hours, I think?
Are you familiar with this part of the state?
No, I'm not.
Had you ever been to Berlin, New Hampshire before?
No,
Have you still to this day been to Berlin, New Hampshire?
I have not.
Now, Caitlin Nafziger, she flew from Minnesota to Boston on February 27th of 2024, right?
Yes.
And then she took a bus to New Hampshire?
Yes.
And then you and or Shannon picked her up from the bus stop?
Yes.
She and Valen, her youngest child, they spent one night with you in Hampton, correct?
Yes.
Can you tell us during that time, did you have a chance to observe Caitlin and Valen together?
Yes.
What were your, without telling us what anyone said, what were your observations of their relationship?
What a good mom she was, and how relaxed the relationship was, and just how happy she was. Both of them.
Had Caitlin ever come to see you in New Hampshire before?
Yes.
How many times?
At least 3, maybe more.
How long had it been since the last time she'd been here?
We have a holiday called Thanksmas, and she...
Thanksmas?
Yes. And we do everything that we've always done, Christmas to Thanksgiving, in 1 week, and all the family gets together. And so she was there for that, as was her mom and husband and other family members.
Her mom's husband?
Mm-hmm. Yeah, her mom, Lori, and...
Okay. Just making sure I know who you're talking
and
about.
Lori's husband, Tim, and my kids, and...
Had Caitlin ever been to Berlin, New Hampshire?
No,
Not before February of 2024?
no,
Did she have any friends in New Hampshire?
no,
Were you her only relative in New Hampshire?
yes,
Besides her husband as well, right?
yes, yes,
And your kids?
yep,
And you, and I don't mean this to sound improper, but you're related to Caitlin by marriage, correct?
Yes.
Now, on February 28th, so the very next day, I mean, Caitlin was in your house for, when did she get there on the 27th? In the morning? Or was it nighttime?
It was evening, and I was working and coming from Boston, so I didn't see her until like 5 p.m.
Okay. So at some point, sounds like less than about, I don't know, less than a day later, you drove Caitlin to that restaurant in Ossipee, New Hampshire, correct?
Yes.
A place called Harley Jack's?
Yes.
Does it take, fair to say it took you over an hour to get there?
Yes.
Had you ever heard of it before?
No.
Ever been there?
No.
When you got to Ossipee at Harley Jack's restaurant, Caitlin got out of the car?
Yes.
She took Valen out of the car?
Yes.
Was Valen in a car seat?
Yes, it was like a car seat that fits into the stroller.
One of those like dual, like
Right.
pop it in and out things.
Right, but
Okay.
she left the stroller portion at my house.
Okay. You didn't go inside the restaurant, right?
No.
When Caitlin got out of your car and took Valen, without telling us what she said or did what she said, how was she behaving?
I mean, it was quite a sad sight, and Shannon and I both cried. You know, she's such a small person, and she had this big, enormous suitcase, and you know, she had the baby in the car seat, and she was just like lugging it. I felt awful for leaving her there.
But you did leave.
Yes, she specifically asked that we not come in because
Objection.
So you left?
Because
Yes.
Okay.
they
You
were
didn't
so
see
ready
the
for that.
defendant at Harley Jack's?
No.
And just so we're clear, do you know the defendant?
Yes.
How do you know him?
We have FaceTimed many times, and I, know him as the father of Valen and Elowen, and because of Caitlin's relationship with him.
You didn't talk to the defendant when when Caitlin was in New Hampshire, correct?
No.
You didn't talk to him in Ossipee in the parking lot?
No.
You didn't talk to him over the phone after you left Caitlin in the parking lot?
I don't even have his contact information.
Okay. He didn't speak to you?
No.
Did you leave before Caitlin went in, or did you watch her go in?
We left as we parked far away in the parking lot and left as she was walking through the parking lot.
Okay. So you didn't wait in the parking lot until they finished lunch and left the restaurant, did you?
No, I had no
Yes.
contact after she got out of the car.
And when you left the parking lot at Harley Jack's, where'd you go?
Home.
Okay. So you drove the hour back to Hampton?
Yes.
You didn't follow them back to Berlin?
No, I was working, and it was 5 o'clock, so Shannon had driven up there, but now I was done working, and I shut my laptop, and I'm like, oh, I can drive home. And she's like, great, because I don't see well at night.
Okay.
So
you wanted to get home?
yeah.
You'd agree that your home is at least 2.5 hours away from Berlin?
Yes.
Now, what defense has asked you about in terms of this plan is that you were going to, the plan was for you to go up and sit at a restaurant on Saturday, correct?
If we hadn't heard from her at that point.
Okay. Did there ever come a time that you heard from Caitlin?
No.
When you dropped her off in the restaurant parking lot, was that the last time you saw her?
Yes.
As part of the plan, did you choose a safe word?
Yes.
What was the safe word?
That
Your Honor, can we approach?
Safe word. What was your safe word? This might be. Defense doesn't want this in. They don't want. Well, I don't think the defense cares about the safe word, but the defense, the fact that there was a safe word involved, indicates that there may have been a level of danger or an issue at play. I don't think the defense is going to like this, but the defense brought up the plan. They questioned, there was a plan. You had this plan. It involved this. It's fair game for the state to say, tell me more about this plan. Was there a safe word? Oh, man. Defense isn't happy. What's the safe word? I see the judge mouth the word safe word. We're buffering a little bit, sorry.
Designed to hurt Elwyn?
No.
Was your plan designed to harm either child?
I did just do
No.
Was any part of the plan to seek money?
Hold on. We're gonna back up.
No.
We're backing up because
Was there any part of the
jumped on
plan
us.
that had Caitlin telling the defendant that she was going to call the police to take custody?
Hold on. We're backing up. Give me just a second. Okay, here we go.
And if you got this code word, you were going to drive 2.5 hours?
I still missed
Is
it.
that fair to
Sorry.
say?
And call 911.
Still missed it. It jumped on us and we missed it. Okay, now we're there. Sorry.
Called it a code word, correct?
I don't recall.
And if you got this code word, you were going to drive 2.5 hours? Is that fair to say?
And call 911.
That's the important part.
Was part of this plan to tell the defendant about it? Would that have made sense to you?
About the
tell him?
code word?
Nope, to tell him about the plan in general.
No.
Was Caitlin going to tell him about it?
No.
Was your plan designed to hurt Elwyn?
No.
Was your plan designed to harm either child?
No.
Was any part of the plan to seek money?
No.
Was there any part of the plan that had Caitlin telling the defendant that she was going to call the police to take custody of the children?
No.
Was there any part of this plan that required Caitlin to tell the defendant that she was going to take the children back to Minnesota?
No.
Did Caitlin have a car with her?
Nope.
Did she have a rental car reservation anywhere?
No.
Did she have a bus ticket?
No.
Was Caitlin familiar in any way with the area in Berlin, New Hampshire?
No.
And the plan was that she would have the 2 children with her, correct?
Yes.
Caitlin never texted you to say that she got into the restaurant okay?
No.
She never texted you to say the defendant was there?
No. She specifically said she couldn't text because he would control her phone.
She didn't call you to say that they were leaving the restaurant?
No.
Did she send you any...
They just approach again, which means I've missed 2 sidebars. I'm sorry. This brings it all the way up to 40. Oh my! So we're getting some in that he would control her phone. I think defense is going to regret calling her as a witness by the time this is over. Little screaming goat here. This is getting tense. Can we see the sidebar, Mr. Cameraman? Can you pan over for us?
answer relative to controlling the phone, and I instruct you to give it no weight whatsoever.
Oh, that part struck.
She didn't call you to say that they left the restaurant, correct?
No, she did not.
Did she send you any photographs of her with the 2 children at his apartment?
No.
Did she text you at any time and say, "Help, please come"?
No.
Did she ever text you a code word?
No.
Did there ever come a time that you heard from Caitlin after you dropped her in that parking lot in Ossipee?
Nope.
Was that part of the plan?
No.
I have no other questions.
Wow.
Ms. Clemunden, part of the plan was for Caitlin to take both children while Dustin was asleep, correct?
No.
That, you didn't discuss how he plays video games, it stays up all night?
Objection, you're not outside the scope.
Approach, Your Honor.
Yep.
41. Here we go. You didn't discuss how he plays video games and stays up all night. He does have a YouTube channel where he was playing video games around this time. And we know he had a computer that he, after grabbing his daughters, after shooting Caitlin, put the daughters in the car, went back and got his computer, put it in the car, and left. Which I would say the computer is the strongest evidence that he was not planning on turning himself in, that he envisioned staying free, being out. Or maybe even hiding evidence that might be on the computer. So that could be quite telling. Yeah, I think the last would be more accurate because he didn't take the monitor. He only took the central processing of the CPU, the main tower, which would contain the hard drives, all the records, the memory, the files would be on there. Brenda's doing well. You can tell she's beat herself up for simple things like driving away before she was in, or not calling or checking. But there were reasons. She's worried that they were worried. They were worried about Dustin, about what might happen, and she's been supportive, not just as a family Uber, but volunteering to pay for the ticket for Elwyn to fly out. It's the what if, yeah. It's the hindsight looking back. If only, right? If only I'd done this. If I'd called here. If I'd gone. If I'd stuck with. If I'd gone in and made sure they were okay. Maybe I might have seen something and been able to call the police sooner, or. Northwest, it's a difficult thing to do, particularly with this story, where it sounds like some of what the aunt knew was only through hearsay. So she did not know independently of herself of whatever situation was existing. That's a quick way to get found guilty in a civil lawsuit, by spreading something that you don't know is true. You suspect about somebody but don't know is true. And doing it on a public forum like a social media channel, things like that, that gets even more tricky. So it's a legal minefield. It's possible that some of that information could come out, but Aunt can tell the news post-conviction. It's dangerous enough that it's a situation I can't because it could jeopardize my channel and my family's income and my home and everything else that I can't get into. I have to be cautious. Defense stayed well away from calling it kidnapping in their questions. Yeah, paying for the mom, or paying the mom to buy a ticket, or reimbursing the ticket for a child's plane ride with the mom is not kidnapping. So there's nothing on Brenda here. I don't think this has helped either. It's possible some of this could come in, for sure, especially if there are any additional charges or other crimes. If he's got a record for something else, some of this might come in. Just after the guilt phase in this trial. Gurley Jones, that would be I think the preferred method from a legal perspective. When they're, two parents, there's currently no court order. One parent takes them out of state. And then you pursue something legal, saying, "Hey, I have equal rights to the child."
Okay, members of the jury, the last question and answer I am striking from the record, and I am indicating that you should give it no weight whatsoever as part of your overall considerations, and you may rephrase.
Thank you.
What was the last question?
Ms. Clemunden, is it fair to say that the plan was for Caitlin to get the girls from the apartment and leave without Dustin knowing?
Yes.
Thank you. No more questions.
Sure.
That's why she wouldn't leave. She wanted him to get on the computer and play games all night, and then while he was asleep, take care of it. State comes back up for another bite of the apple.
Ms. Clemunden? You've just testified that the plan was for Caitlin to leave with the two girls, correct?
Yes.
Without the defendant knowing?
Yes.
Caitlin did not have a car?
Right.
Did not have a bus ticket?
Right.
Did not know the area?
Right.
You were 2.5 hours away?
Yes.
She didn't know anyone else in the state?
No.
It was February in Berlin, New Hampshire?
Yes.
Fair to say the temperatures range between -2 and 32?
Yes.
Fair to say that it was snowing that week?
This is beyond the scope.
Overruled.
I don't recall.
Okay. I have no further questions.
Okay, counsel approach, please.
Sidebar 42. Oops. I broke it. There we go. There's 42. Judge called this one. Hello. He sounds like the judge. Hello. All my friends are JPEGs. Welcome. We're in the last stages of a murder trial where the defendant is accused of shooting and killing the mother of his 2 children. He says it was self-defense because she was going to kidnap them. He then took the kids in his car, went dark, just driving off into other states. Amber Alert was issued. He was spotted in his car the next morning and taken into custody. Daughters are safe with the grandparents, but the mother was found dead in his apartment with a single gunshot wound to the head. And he's admitted to doing it, saying it was self-defense.
Thank you.
And Brenda, released, can now sit with her family and watch the rest of the trial. She's no longer sequestered. And we come back up for 43. Lots of sidebars here. Did she do a bird? I didn't see a bird. We avoided spice and mistrial. We got the tension. There's still a looming question that probably the jury can see. I'm wondering why, we'll disregard the safe word and disregard a couple other things. Oh, you heard a bird. It's the squeaky gate. Sometimes, occasionally, we'll see someone flip the bird as they're walking out of court and look at the defense. But now defendant needs to testify. I don't think he can. I think that would open all sorts of doors. I think defense has said she is their witness. It was the gate. It was the hinge separating the gallery from the well. Drama Llama moment. There has to be something admitted into the trial that brings up the question of self-defense or the allegation of self-defense. Defense has argued it, possibly because it was in his statement to the police, and that was brought in. And that, I think the judge ruled that was enough that they get to claim this is a self-defense case without him testifying. If there was nothing there, like imagine, say, Sarah Boone, right? Imagine Sarah Boone, she's trying to say it was self-defense, then there's nothing in evidence to support that.
Okay, members of the jury, we are going to take an early lunch break today.
Ooh.
Okay, we will take the noon hour a bit early, and so we will break now. We are going to reconvene at 12:45. I'll expect you folks back at 12:45. I will meet with the lawyers before that, but I would ask that you be ready to go at 12:45. It is currently 11:30. Again, consistent with all of my instructions, do not discuss the case amongst yourselves or with anyone else. Conduct no research as to any matter. Don't transmit any matter through your own social media. And if you see someone in Lancaster, please don't talk to them. But other than that, thank you for following my instructions, and we'll reconvene again at 12:45. Thank you. All right.
Okay, we're just going to wait and hear. Maybe the judge will tell us what time they're coming back with the lawyers. Either they're going to have the meeting right now before lunch, which it doesn't look like they are because the state has pretty much grabbed everything off their bench. Yeah, find a flag. There we go. Looks good. I feel like a hairdresser with bad eyesight. Looks like...
Then the lawyers, I'll just confirm that what I've indicated is we will reconvene court at 12:30. I know that I indicated that the jury to be back at 12:45, but my expectation will be to confer again with the attorneys at 12:30, and the court will be in recess from now until 12:30. Is that sufficient, counsel? Sufficient? Okay, all right, thank you. Court will be in recess.
All right, so they go in recess. They're going to be back at 12:30. We're going to get everything set up for a 12:15 return. Day 4, part 2 is where we are. We'll have a portal to bring you there, so no worries. You don't get lost on the interwebs. Come back at 12:15. How about that? That only gives us 45 minutes for lunch, but 45 minutes is enough. It's built, and nobody's in chat yet. Look at that. We'll see who gets there first. It was Greeners. Followed immediately by Kimar, like milliseconds later. And then Fire Girl. All right, we'll get that. We'll get the portal set up so we can transfer everyone over from one to the other. This, I think we're going to have the defense rest. I think we might have to have a colloquy with the defendant. Hello. You might have to have a colloquy with the defendant in front of the judge about testifying, if he chooses to testify or not testify, and that should be done in less than 15 minutes for sure. I'm sure they've already made that decision. So we're breaking for lunch right now. That's what we're doing.
Hello.
All right, portal set up. Recommendations for you. Limit disruptions for channel members. Automated ads help you earn more while optimizing the experience for channel members. Turn on automated ads. It doesn't do that. It doesn't do that. I'm sorry. It really doesn't. I'm not turning on ads. Is Stubby broken again? I don't think so. Let me check.
I saw a chicken fight.
All right. We're going to go to lunch. When we come back, we're going to have the conclusion. Stubby might be broken. Man. I'll fix it. Let me just check and see.
What more do you need to see?
Hello.
Should work. It's connected.
Because he's the guy.
I think somebody used it when it was quiet. That's all. So. All right, we're going to go to lunch, and hope you all have a great lunch. When we come back, we'll be back at 12:15, which is in about 42 minutes. 42 minutes. We'll have part 2, day 4, coming at you, which might get us all the way into closings. So we might
put a diplomatic plate on a hoopty.
We might have closings this afternoon and possibly begin deliberations as soon as, well,
The zombie apocalypse may be
I
upon us.
think deliberations are going to be on Monday. The reason why I think that is because we haven't heard them discuss the jury instructions yet, right?
Hello.
I don't know. We'll have to see if they've done that already. All the trials run together. So, all right, let's play the music and grab some food. We'll be back. Save your seats. There we go. I forgot to turn my lights on. These are my police lights. Oh, not anymore. They changed. That's as close as I got to police lights. All right, tonight when you go home, please hug the people you love, smile at someone to make their day just a little bit better. Please stay safe till we go live again in 41 minutes. 41 minutes. Grab some lunch, come back in, have a seat. Closings are where everyone's going to button this all up and put it all together and spell it out for the jury, and then ask the jury to make a decision on the guilt and innocence. I think I'm ready to put a poll up as soon as we start as well, if that's the case. So. Right, have a great lunch. We'll see you after. Bye-bye.
Hush! I'm trying to have court. Don't raise your voice again.
Hello. Hello.
bigger than
Hello?
It's bigger than me. It's bigger than all of us.
The zombie apocalypse may be upon us.
Are we going to adjust subject matter jurisdiction?
You don't put a diplomatic plate on a hoopty.
Don't miss the forest for the trees.
I was told council wanted to see me at sidebar.
Hello?